Alexander Jeffrey with the Clark-Esposito law firm, PC. Today, I'm with the managing attorney to talk about the best options for handling a U.S. Customs seizure.
Thanks, Alexander. Great to be here with you.
No one likes getting a U.S. Customs seizure notice. Can you explain what that even is?
A U.S. Customs seizure notice is a document that indicates that a law has been violated, and as a result, Customs has decided to seize your merchandise. That is, they've taken your merchandise, and based on the letter, they don't plan on returning it to you.
When U.S. Customs notifies you that your goods have been seized, does that mean that you can never get them back?
That's a great question. And the answer is not necessarily. Each seizure is specific to the facts of the underlying transaction. What that means is that sometimes the shipment can be released in full, sometimes a partial shipment can be released, and sometimes none of your shipment will be released.
So, under what kind of circumstances would an entire shipment be released?
Well, one example is where an importer has done something and it looks like something is wrong, and it turns out nothing is wrong. So for example, if we take the case of an importation of trademarked goods, that is goods with a brand on it, and with that shipment, Customs doesn't see any authorization by the mark holder, the trademark holder, that you are allowed to import those goods, they'll take it, you'll seize it. But where you're able to come back with a letter from the brand holder saying, you know what, this importer is authorized to import these goods, then that is an example of where Customs will go ahead and release the shipment.
Under what kind of circumstances would a partial shipment be released?
Well, this could happen where a shipment contains both violative and non-violative goods. I'll give you an example. I once dealt with a case which involved a shipment of what the importer believed was costume jewelry. And part of this costume jewelry was knockoff Chanel jewelry. They were not expecting this to be in the shipment. So because only a portion of it had been violative, we went ahead and asked Customs if they would release the non-violative portion of the jewelry, which they went ahead and did. This benefits the importer because the importer is now able to go ahead, sell that merchandise to its purchaser, without further delays, while dealing with the remainder of the jewelry and the customs issue.
So could you tell me under what kind of circumstances would a shipment not be released at all?
Well, this will be the case where an importer is unable to substantiate the violative nature of it in that it is not violative. Staying in line with the trademark issue, this would be the case where the importer is unable to obtain the letter of authorization from the brand holder. Without that authorization, Customs won't release it and the merchandise will be seized.
Okay, so what would be the best way to handle a customs seizure notice?
Well, the best way to handle it would be first to understand which of these three categories does my shipment fall into. It probably can get out, maybe only part of it can be released, or they're going to take the whole thing. Of course, when it's the third option, where it's believed that Customs will take the entire shipment, that gets more complicated, and that's where you want to go ahead and bring an attorney in. Of course, you'll want to start out, see if your freight forwarder can help you or your customs broker. Oftentimes they're one and the same, if they can assist. But where you're faced with few options or even no options, then you want to go ahead and speak to an attorney. In addition to this, intellectual property reasons aside, there are several reasons why Customs will not release cargo. And some examples of this include maybe the shipment is simply prohibited merchandise, like a shipment of bongs, for example. It could be that the products are inadmissible, could be spoiled food. Well, FDA won't allow, spoiled rotten food to come in, so Customs has to seize it and not allow it to come in. Another reason could be that the imports are labeled made in the USA. Well, if something's being imported, by definition, it cannot be made in the USA. So you want to be sure to pay attention to all of the correspondence that you have with US Customs. Keep in mind, Customs keeps track of who has had prior seizures, who has had certain issues. Even they trace back to the factory, and sometimes they say, oh, you know what, we know this factory to be problematic. So if you have an issue, and in particular, if the goods are in that third option that is probably going to be seized, you want to submit an explanation letter along with the seizure notice And you want to do this in order to clear your name, if you will, okay? Because this way they have a written, documented history by you of explaining why you came into this incident involving a seizure notice in the first place.
And what if you're not sure about what to do? Should you contact an attorney?
Yeah, well, like I was just sharing, oftentimes importers will start with their customs broker or their freight forwarder, and they're wonderful resources. And in my experience, they always do try to help. And I love the trade community. Again, where it seems like, I just don't see a way out, whether it's engaging a law firm so that a lawyer can help you better represent the facts, whether it's that they need, or rather you, the importer, need help to try and obtain some other information, or maybe you remember something happened somewhere and you heard this could be possible. Maybe there's a way to get some of your shipment released. So we go from nothing being released to some of this will get released. Again, your underlying transaction is what is going to lead to the result and the best approach that your lawyer is going to take with you. So you want to be sure to give all the information you can about the transaction to your lawyer.
How soon should someone contact an attorney?
In terms of contacting an attorney, the sooner the better. You want to contact them because all law firms have different processes for bringing on potential new clients, and it may take you several days before any attorney is even available to meet with you. So the sooner the better. You want to go ahead, reach out to a customs attorney and get the help you need.
And what would be the best way to get in contact with our firm?
Well, the best way to reach our firm would be to do one of three things to learn about our paid consultation process. The first would be to call our firm at 917-546-6997. The second would be to send us an email at contact@Clark-Esposito.com. And the third would be to go to our website, www.Clark-Esposito.com, and fill out the contact form. Explain briefly the nature of what you're contacting us about, and someone will contact you quickly.
All right. Well, thanks, Deanna, for taking the time to go over these points with me today.
You betcha. Thanks, Alexander.
Subscribe and click the bell icon so you'll be the first to know when we upload a new video. Check out our playlist if you want to see more of our videos, and comment below and introduce yourself. We'll see you soon.